Evicting a tenant can seem like a complex process, but in this video we'll quickly explain the eviction laws in Wyoming and outline some simple steps that landlords can take to initiate an eviction. We're eForms, the largest online database of fillable legal forms, and in this video we'll talk about what the eviction process looks like, how Wyoming laws affect evictions, and how to legally remove a non-compliant tenant from a property. Be sure to watch to the end of this video to find a link to a fillable eviction notice that complies with Wyoming requirements. First, what is an eviction? Eviction is the process of legally removing a tenant. Even if a tenant has failed to pay rent or done something wrong, it's illegal for a landlord to change locks on a property or physically remove a tenant from that property. If the tenant refuses to leave after violating the terms of a lease agreement, a landlord must seek an eviction from the court. Eviction, it should be noted, is different from the simple termination of a lease. A landlord can opt not to renew a lease after the specified term has ended, and there is no need to involve a court in this process. If a tenant in Wyoming violates the terms of a lease agreement, the landlord can serve an eviction notice on the tenant. In Wyoming, this is also known as a 3-day notice to quit. This can be used if the tenant fails to pay rent or commits some other breach of their signed contract. It tells the tenant to pay or fix the problem within 3 days or face eviction. This notice shouldn't be confused with a 30-day notice to quit, which allows either the landlord or the tenant to terminate a month-to-month lease agreement. This can be used regardless of whether the landlord can prove that the tenant has committed a breach of the contract. A copy of the eviction notice should be served on the tenant. Per Wyoming law, this must be done in person. If the tenant cannot be found, then the landlord can leave the notice at the tenant's place of residence or work. If the tenant does not respond to the notice, either by moving out within the allotted time period or resolving the matter identified in the notice, then the landlord can file an eviction action. The landlord can do this by filing 2 forms known as a complaint and a summons for a writ of restitution in the local circuit court in the county where the property is located. At this point, the court will engage a process server to serve copies of these forms on the tenant. After receiving the eviction papers, the tenant has a right to file a form known as an answer with the court. This is basically a counterclaim to the landlord's complaint. If after hearing both sides of the story, the court rules in the landlord's favor, then the landlord will be issued a writ of restitution. This document can be taken to the sheriff to authorize an officer of the law to remove the tenant and the tenant's belongings from the rental property. The law around eviction can seem daunting, but we've got everything you need to get proceedings going, from eviction notices to court documents, and you can access all of it at the link below. Also, don't forget to hit that subscribe button for more videos about important legal issues in business, real estate, and more.